For immigration law,
speak to Tan Law Solicitors.
for family law,
Speak to Tan Law Solicitors.
for employment law,
Speak to Tan Law Solicitors.
for wills and probate.
Speak to Tan Law Solicitors. At Tan Law Solicitors, we are on your side. Our proficient lawyers offer a range of legal services for both individuals and businesses. Book your 15-minute free consultation and mention the word radio. Visit tanlaw.co.uk.
For immigration law,
Speak to Tan Law Solicitors.
for family law,
Speak to Tan Law Solicitors.
for employment law,
Speak to Tan Law Solicitors.
for wills and probate.
Speak to Tan Law Solicitors. At Tan Law Solicitors, we are on your side. Our proficient lawyers offer a range of legal services for both individuals and businesses. Book your 15-minute free consultation and mention the word radio. Visit tanlaw.co.uk.
For immigration law,
Speak to Tan Law Solicitors.
for family law,
Speak to Tan Law Solicitors.
for employment law,
Speak to Tan Law Solicitors.
for wills and probate.
Speak to Tan Law Solicitors. At Tan Law Solicitors, we are on your side. Our proficient lawyers offer a range of legal services for both individuals and businesses. Book your 15-minute free consultation and mention the word radio. Visit tanlaw.co.uk.
Hello, everyone. My name is Andrew Nyameyaro, and I am a solicitor at Tan Law Solicitors, and I'm here to make a presentation on immigration. Today, I've received a few questions. I put messages on various platforms to ask for questions that people might have on immigration, and I did have a few questions that I received. So if you can hear me properly, just put a message in the chat so that I can know that people can hear me and can also see me properly, and then we can proceed with what I have. So I would appreciate if someone can just put a thumbs up or can just chat something in the chat, and then I'll know that people can hear me and they can also see me. Thank you so much. I'm just waiting to just get a thumbs up. If you can hear me or see me, just put either a thumbs up or just to say hello. Okay, thank you so much for the confirmation. Please just call other people or just forward the message to other people that we are now live. Okay, so I received a number of questions, and if you are here and you have not given me your question, you want me to respond to your questions, you can just get in touch with me either on my WhatsApp or you can just put it in the chat, whichever way you prefer. It's okay with me, so we can do it that way. You can either put them on WhatsApp or you can put it on the chat, because I can see my WhatsApp here as well. Okay, so the questions that I received come up to about 11 questions. Some of them were almost similar, but if you have any other follow-up questions or any information that you would want after this, you can also get in touch with us. The presentation, as usual, that I make is on a general position. It's from a general approach. This is not individual to any person. Any questions that individual information, I have tried to anonymize it as much as possible, because I cannot discuss people's individual circumstances online in a public forum like this. Anyone who wants bespoke advice can either approach us or they can approach any other legal advisor of their own choice. So please, whatever we discuss here is treat it as general advice, and for specific or more detailed advice, then you need to consult with your own legal advisor, who can be ourselves or any other business or organization for that matter. So the questions that we received, we'll start with the first one. Can a dependent wife or a partner get a COS and sponsor the other partner and children given the current laws? So the issue of dependence has been going on for a while, and it has become a topical issue since there was a large influx of sponsored immigrants from the time of the health and social care visa. So the Home Office or the government estimates that, for example, in 2024, 2023, there were over nearly 150,000 or so dependents that came over into the UK. But the Home Office then changed the law last year, around March time, the 11th of March, where they said that anyone who is going to come on a healthcare visa, particularly 6135 and 6136, which is the carer and senior carer visas, they will not be able to bring in their dependents. So there is a lot of technicalities that are there, particularly for people that maybe came on those SOC codes, 6135 and 6136, but ultimately switched to other SOC codes, and again then tried to re-switch to the care visas. There's some technicalities that we can discuss should that need arise. And then there are some people that came on a different SOC code, a standard occupational code, that is different to the 6135 and who switched later on, or who came as students or were dependents or had any other sort of visa, one way or the other, who then wanted to go on 6135 and 6136. So the law on dependence initially affected the carers and senior carers, that from March 2024, they could no longer bring in their dependents. So there was a provisional arrangement that was there, that those people that came before the law changed could still bring their dependents. I know a lot of people rushed to bring their dependents then, but some waited, and a number of them, they're still trying to bring their dependents, either their partners or their children or whoever was dependent on them up until now. So since the law changed, you cannot bring your dependents if you're on 6135, 6136, and if you were before the law changed, then you can bring your dependents. So yes, a dependent can get a COS and the children can get a COS under the current law, as long as the sponsored employee or the sponsored migrant worker qualified under the transitional arrangement that was there. Adding to the mix is the issue of dependence of graduates. As you would know, in July this year, there was the white paper that was announced by the government, and one of the things that it was dealing with was to deal with the increased requirement of qualification from RQF level 2, which is most of the carers and senior carers, to RQF level 6, which is a graduate level now. But the other change that has been implemented or is being implemented is that anyone who is coming to the UK to study and is studying under the PhD level may not be able to bring their dependents. So there's a lot of things that is happening to the laws relating to the dependents. So I hope this answers the questions for the dependents. If not, just either WhatsApp me or send a chat there. The WhatsApp number is there on the screen. You can see it. Question number 2. Is it still possible to get a visa via partner route? I've heard many people trying this route saying they were refused. The Home Office asked them to go back home and apply from there. That's an interesting question. So when we speak of the partner route, as you are saying, the first thing is we ask ourselves, is partner under which route, and who is going to be sponsoring this partner? Because there's different ways in which someone can be sponsored as a partner to come to the UK. One, someone can come as a partner of a refugee. That has got different requirements. A partner of a skilled worker has got different requirements. A partner of a person who is British or has got indefinite leave to remain has got different requirements. And a partner of someone who's an EU citizen who can come under the EUSS or now, which is generally the same as the standard partner visa. So since the majority of the audience that I'm talking to, or the people that I'm dealing with at the moment in this presentation, is from the care sector, I would assume for the purposes of this presentation that it's a partner of someone who's a carer or a senior carer. So yes, like I said in the first time that I talked about this issue about partners, you can bring your partners if you are able to show that you were in the UK, which the Home Office will know anyway before the 11th of March 2024. However, for other people that we've got their partners, the Home Office will always ask a question if you're going to bring a partner, if you've got a partner here, particularly partner, if your partner was not legally in the UK. The starting point, especially if the partner was not legal in the UK, is that they should leave the UK and apply from abroad, unless if there is exceptional and compassionate circumstances as to why they can apply from the UK. And also maybe there is children that are involved, and it will be in the best interest of the children to remain, for the children, that the parent is not removed or forced to go out of the country so that they can come back. We use, and there's also what we used to call the Chikwamba principle. The law is also changed in a number of ways regarding that. But the general thrust still remains the same, that if you are a partner, then you need to meet the partner requirements. And if you meet the partner requirements, is it necessary for you to remain in the UK to make the partner visa application? If you are legally in the country, most of the time that will not be an issue. You can then switch from one route to the other as a partner, as long as you meet the requirements. So when people are being asked to go home, it's because there would be factors that ordinarily the entry clearance application should have been made, or is the right way to proceed under the circumstances, unless if there are reasons such as the presence of children in the relationship, any serious medical problems, any other difficulties that might be faced by the sponsoring partner and the sponsored partner as to why they cannot have the person applying for the visa leave the country. So this is again a case whereby you need to seek legal advice and explain to your representative your particular circumstances, and your advice would be made in accordance with the bespoke circumstances of your case. What happens to children born in UK to carers who came after 11 March 2024? And in the event that they get 5 years to be British, can the parent apply as parents to a British child? So there's two things that the person is asking here. What happens to the children? So any child for any person that is in the UK legally will assume the status of their parent. So in this case, if a child is born in the UK to a parent who is in the UK, then that child will assume, because they are not coming from abroad. Coming from abroad, that's what the Home Office told. But if someone is born here as a child, then they will assume the status of their parent. So they will just get on as a dependent of their parent. But however, this person is not fully informed on the issue of British citizenship. A child does not necessarily become a British citizen at 5 years, as the person seems to suggest. So it could, there's various factors that are included there. The child might have to start as indefinite leave to remain, so they'll go on limited leave to remain, indefinite leave to remain, become British, and so forth. And one of the good things that came from the white paper is that it has tended to clarify and make simpler the visa processes for minor children, particularly in regards to citizenship. But it's not automatically that at 5 years they will become British citizens, and the parents cannot also become British because the child has become British. There are requirements for each route as well. So the parents would need to do, as we speak, as of now. And again, it's important for me to tell you that in September, the Home Office is going to introduce their next batch of updates. And those updates, we know what they mean, changes to the immigration law under the white paper, that they're going to do it. But currently, as well, even today, as I speak to you, there is a change that has been proposed by the Home Office, or is being implemented rather by the Home Office, in regards to the asylum process, the tribunals, for that matter, the first tier tribunal. There's a backlog, a severe backlog in the first tier tribunal, and a backlog in the Home Office case working department as well. So there are some people that have been waiting in their asylum cases for a very long time, and there is also people that have had cases in the upper first year tribunal waiting. I've had clients that have been waiting on their cases in the first year tribunal for more than 12 months, although the Home Office estimates that it's around 53 weeks, which is about a year, but I have clients that have been waiting for a longer period. So these changes are always coming in. And the other change that is likely, back to the point that we're discussing, is that at the moment, settlement is after 5 years, but the Home Office or the government have proposed that settlement will be at 10 years, and that is going to affect a lot of people. We are not yet sure whether this will affect them retrospectively, or it will be prospective for people that are going to be affected from the day of implementation. But as we speak, it might move from 5 years to 10 years, which means that people have to be strategic in the way that they are going to deal with their immigration journey in the UK. If you are almost close to your 5 years on a limited leave to remain on whatever route you are, or skilled worker, then I would urge you to then consider to become settled as soon as possible. You have to make sure that you have started to meet the other requirements, which are, for example, the English test, the Life in the UK test, so that as soon as you qualify, you can then go on that settlement. And remember, settlement, especially for people that are on the care visa, settlement is not cheap. Settlement is very expensive. You're looking at around 3,000, 3,200 or so for each individual to go on settlement. So you need to also budget your funds or fees if you were not budgeting your money as of yet for your visa. So that's about the children, whether when they become British, how they become British, how it affects the parents, etc. So just checking on some questions. Okay, so the next question: my children were granted entry clearance. I wish to change my employer and get a new COS on the same SOC code. Will that affect my children who are still abroad? So if your children were already granted their visa in whatever country they were, but by the Home Office, and you were working for company A, now your company B is offering you a COS and you want to accept that COS, and then I can say, yes, you can accept the COS of company B. And I would say, if your children can come immediately without any delay for any other reason, that's the best position. They can come. But if they are going to come at a later stage, then before they come, make sure that you have submitted your application Why do I say so? Because when you make your visa application for the new company, or when the new company makes requests for references to the current company might then write to the home office to say that you are no longer working for them, or you're leaving them, or things like that. We don't know how they will react or react. Then if once they inform the home office that they're no longer sponsoring you, you might end up getting curtailed. So you need to be very strategic in this circumstance about your children. If they can come straight away, that would be the best possible solution. If not, as soon as the company gives you a new COS, you submit your visa application. And if you can afford it, try to put the visa application on the priority. If you can do priority, if you can't afford priority, these visas for the skilled worker visas, they don't tend to take a lot of time. Normally they would take a week or less most of the times, but they might also take long if the home office believes that it's a complicated case. The home office are in a habit these days of sending an email to say your case raises very complicated issues, this and that, because they would be trying to buy time, especially when in terms of their standard procedure, they are getting into breach of their own timelines and so forth. So yes, you could potentially get the new COS, make the visa application, and on the face of it, it will not affect your children. The next question: the best other way to come to UK with skilled worker visa, now healthcare sector is closed. So the healthcare visa sector is not closed necessarily. What has been closed is the senior carer and the carer. You cannot get a defined COS. You cannot bring people from abroad only on the carer and senior carer visa. Every other visa is still open. You can come under the health and social care because it has got a number of categories under that route. We have got nurses, doctors, radiographers, and different stuff in there, nursing auxiliaries, etc. There's a number of other support workers, housemasters, and so forth, things like that. Off my head, those things that qualify under the health and social care. So it then also depends on whether under health and social care is that so-called still under the immigration salary list, or is it still under the temporary shortage list, which was introduced in July last month. So you can find, if you can fit into the other health and social care routes, you can go under that. But nonetheless, people can still come under the skilled worker, but the skilled worker is a lot of jobs under, like I've said, under the one, the immigration salary list, two, the temporary shortage list, three, the transitional arrangements, four, any standard application where you can show that you have not been able to get an employee in the UK after you have made your visa up, you have made your adverts or tried to recruit from abroad, etc. So it still remains open to people if they meet the requirements. So we've got things like IT, lawyers, managers, HRs, and so forth. Skilled worker covers a lot. So they are still there if you meet the requirements, the qualifications, and so forth. All you need to do is to check. If you check on the GOV website against your qualifications or against your experience, you can see if you can be able to come to the UK. But as a sentence, yes, you can come to the UK on other routes. It's only the 6135, 6136 that cannot bring you to the UK anymore under the defined COS. So the next question is quite loaded. It has got a lot of things, and it's affecting a lot of people. So this is about family. You know, you bring your partner to the UK, and life takes course. Either you are living happily ever after, or you're having issues in the relationship. And once you've got issues, how are you dealing with the issues? Is it leading to separation or a divorce? How is it affecting the children? How is it affecting the relationship? And ultimately, how does this affect on the visa? So the person who gave us the scenario is coming from a position of the sponsor, the sponsored immigrant worker who brought their partner, and they're having issues, and to such an extent that it seems almost viable that the sponsored immigrant is resolved to terminate their relationship, and obviously inform the Home Office that the relationship has come to an end. And once that happens, then the partner will have their visa curtailed, and that will affect the partner and most likely as well, possibly the children of the union. But the partner is also saying that I will also inform the Home Office that when you brought me to the UK, you brought me under false pretense. You didn't tell the Home Office the whole story, and I will report to the Home Office so that your visa can also be curtailed. So this is quite a complicated situation, and the relationship is broken down. So it is up to the sponsored immigrant worker to report to the Home Office. If they want to report to the Home Office, they can report to the Home Office that the relationship is broken down. We are either divorced or separated or not living together. Once that happens, the Home Office mostly is going to curtail the visa of the partner, and the partner will be given the curtailment later, the 60 days later, to either leave the UK or to find alternative ways of staying in the UK. So since there is a child or children involved in this relationship, the partner that has had their visa curtailed, if that meets their requirements, can also raise issues to do with human rights based on the child that is in the UK, or they can just also make their own application to the Home Office, maybe get their own certificate of sponsorship or any other way that they can apply if, for example, they fit into the human rights or the protection, asylum, or they've got they've under circumstances they are going to study, find their own COS and so forth. And if they are going to whistleblow on the sponsored immigrant, obviously the Home Office doesn't just act on whim. We have seen such cases whereby the Home Office will then write to the sponsored or sponsored migrant worker to ask them that this is what we have heard. We are giving you 10 working days, 20 working days to respond and tell us your side of the story. They will review the case. If you produce a plausible case to them, then your visa will not be curtailed. If you can show that obviously you were in the UK together, I'm sorry, I'm saying in the UK, you were together in your home country, you've got children, you've got birth certificates, all those kind of things, and maybe there's a marriage certificate, etc. Then the chances are when they came to the UK, they had a relationship with you, and it is now broken down and so forth. So it's up to the sponsored migrant what they want to do. If they want to just stay under the threats of the partner and live a very difficult life, they could do that. If they want to free themselves from the partner and tell the Home Office and separate, then they can do that. And if the partner then raises issues against the sponsored migrant worker to the Home Office, then the Home Office, and most of the time, will give you a chance to respond to the allegations that have been raised. So people are experiencing a lot of different issues in the households. Some is to do with children. Some children are now into crime, into drugs, affecting a lot of things. Some taken into foster care and so forth, and relationships breaking down. So if your relationship is broken down, is particularly for people that are on a limited leave to remain, then the sponsored partner will need to look for their own way to remain in the UK. Like I said, from a general rundown of these rules, it could be human rights, asylum, sponsored worker, student, innovative, any skilled worker route can be available to them. I hope I've answered that question. And if not, the person can then come back to my inbox and we can discuss further from there. The next question is, can I work 20 hours part-time jobs without doing the main job sponsored full-time? So my understanding of this question is we have got A, who came to the UK as a sponsored migrant, and they are being sponsored by a company C. So the company C is either not sponsoring them anymore, or maybe they're not giving them the hours to work and not paying them. By the way, where the employee is offering their services to the employer and the employer doesn't have the hours, then the employee is entitled to their full salary. So it's up to the employer if they don't have the full salaries and the full hours, it's either to terminate the employee contract or to pay them without work. And in this case, rather than not to pay them at all, because that will be a breach of the Home Office and most likely of the HMRC requirements as well. But under the circumstances where someone is either not working for a main employer or the employer is not giving them the hours and not paying them, and they want to do 2 times 20 hours, first of all, you cannot do additional work more than 20 hours. You are limited to 20 hours to do your additional work. So if you're going to do 2 of them, it means that maybe you've not informed the other company about it. And it's also a requirement that where you're going to do your additional hours, you should be doing your full-time on your sponsored work. So if you're not doing your sponsored work, you cannot do the additional hours. I know people, for survival reasons, have been found in circumstances where they're just doing the 20 hours, or maybe like in this case, someone has had to resort to you doing as many hours as possible through various guises, like in this case. But the legal position is you should be working for your sponsor your full hours, and then you do the additional hours of 20 hours per week. It's per week that you will be doing. So you cannot, according to the law, do 40 hours based on 20 hours without working for your main sponsor. How long is the waiting period for the Home Office if you have done an appeal regarding your immigration status? I commented on this one briefly. So the appeals, they are taking around 53 weeks, according to the Home Office. In reality, I know that it's going beyond that. I've got some cases that started in 2023 that are still going on at the moment. But however, the Home Office and the government have announced that they want to expedite the process. So we'll see how that will work out. But on average, it's taking around 53 weeks or so, according to the Home Office. In my experience, we are talking about 12 months or so going forward for how long it is taking. And again, people that are on the skilled worker or sponsored route, if your application is refused or rejected or not dealt with accordingly with the Home Office in one way or the other, then you've got 2 ways of challenging it. It's either you go for what is called the administrative review, or you go for the judicial review, depending on what the challenge you want to make. Administrative reviews, they're taking up to about 6 months for you to get a decision on an administrative review. So you have to consider, is the administrative review the best route that I want, or can I just make a new application and reapply again? Of course, reapplying again might mean a lot of money, because if you had been given a COS that has already been used, it means that the employer will have to generate another COS, costing them the ISC and the COS money, and yourself, it will be costing you again your visa money and so forth, while the administrative review is only £80. So you have to consider again the issue of Section 3C, the extension of your visa, and that you don't overstay your visa by more than 14 days under the Immigration Rule 39E. So you need to really consider all these things. Yes, in response to this person's question, appeals on average 12 months, administrative review on average 6 months, judicial review, pre-action protocol normally 14 days. They normally reply within the 14 days, or you can give them a bit extra. They can go a bit over, and then you can have to nudge them to reply and so forth. But if you're going to go for judicial review, you have to make sure that your case is in court 3 days less 1 day, so because you have to beat that deadline for it to be in court for the judicial review to be valid and accepted by the relevant court, whether it's going to be the High Court or the upper tribunal. I am eligible to apply for indefinite leave to remain next year. That's 2026. My family arrived in the UK in 2024. Which visas would they need if I get indefinite leave to remain, as they will be eligible later? So again, in this case, if you are eligible for indefinite leave to remain, you are saying you will be eligible 2026, and we are just hoping and praying that they will not increase the period from 5 years to 10 years. If they do increase it from 5 years to 10 years, then you might not be eligible next year. You have to do another additional period of 5 years. So will your family have to do an additional 5 years as well to make it 10? And under those new proposals, they've also introduced what is called end settlement. You have to earn your settlement if you're going to get settlement for less than 10 years. If they implement it, are they going to implement it? My hunch said they are likely to implement it with what is happening in terms of immigration these days. So they will end the settlement is where they will look at what you have done in your career. Maybe you've done something that is outstanding in your career. What have you done in the community? What have you done that is outstanding for you to say that this is something that makes you deserve to become settled earlier than anyone else? So I'm just encouraging people out there that for you to have the end settlement, you need to be doing things, maybe some voluntary work in the community, or doing some outstanding work, or getting some awards or achievements here and there, so much that the Home Office will recognize you as an outstanding citizen and therefore give you that settlement earlier than everyone else. So if you then get the settlement, your family will still remain on the limited leave to remain, and again subject to requirements and the visa conditions. Then they will have to fulfill their own 5 years as well for them to get on indefinite. So I think the question also becomes tricky, where the visa of the dependents is going to finish before they come to the period of applying for their own indefinite leave to remain. What visa are they going to go on to? Under those circumstances, now they will become dependents of a settled person. And dependents of a settled person, particularly if you were on the healthcare visa, where you were enjoying cheaper fees and less stringent conditions, this is now a totally different ballgame. If they are going to apply as dependents of a settled person, they are now going to look at the household income. So the household income should be 29,000 as we speak. Any adult dependent might, again, considering the changes that are being proposed under the white paper, might be required to do the English test. It's something that we are waiting to see, which might be implemented as well. So they might be asked to do the IELTS. So it's something that they have to look out for. So household income, accommodation, and then the rest of the information, pay slips, bank statements, letter from employer, proof of relationship, etc. And the fees now would be higher. They will not be subjected to higher Home Office fees. Currently, it's around £1,260, for argument's sake, 1,300. The insurance health surcharge, 1,260 something pounds, for argument's sake, 1,003, 1,000, so 2,000 600 for argument's sake. So each applicant would then be facing the issue of around £4,000 for them to be dependents of a settled person. So that's where you need to consider budgeting your money. If you go on settled, it's important. It's good that you're on settled, but the visa for British people, dependents, settled people, other routes which are not the care, then social care visa, the visa fees and the insurance of the charge is quite high. So that's how they will be dealt with. Let me just look at questions that I have. How hard is it for a Canadian to get UK citizenship? If someone is Canadian, they're just treated like any other immigrant. They go on their limited leave to remain, then they go on settlement, and then they go on UK citizenship. UK citizenship comes ordinarily, and I say ordinarily because there could be other circumstances when you're looking at the partners who get maybe their settlement earlier, or if they were married to with certain conditions, 3 years or 5 years, whatever. I'm not going to get into those complications at this stage. But it's not about the nationality of that person necessarily. It's about meeting the visa requirements of the current visa that they are on. So it can be a Canadian who is a student, or a Canadian who is on a sponsored visa, or is a Canadian who came as a spouse of a British person, or a Canadian who came as a spouse of someone on limited leave to remain, and so forth. As long as they meet the requirements, it doesn't necessarily mean. I think for Canadians, their own benefit here is that they are not required to do the English test, because Canada is regarded as an English-speaking country, and also the Canadians. Okay, yes, I've remembered the point. And also, Canadians are not required to do the TB test. So that could be maybe there are two benefits there off my head. What can you do if a visa takes more than 5 months within the UK and there's no update at all? 5 months, if the Home Office, 5 months is nothing to tell the truth at the moment. We have had clients that are waiting up to about 12 months. And normally they would write a letter to say if it's less than 12 months of 6 months, don't contact us. But obviously, as lawyers, we do write to them chaser letters, and at some point, deservedly or not deservedly, some pre-action protocol letters, depending on the circumstances. So 5 months, I would say they are still within the timelines most of the time. I would say if it goes beyond 6 months, or maybe up to 12 months, then maybe you can consider doing a chaser letter or asking your lawyer. If you don't have a lawyer, it's also good for you to approach your local MP. Local MPs are very useful in immigration cases. So you can go and see your local MP and ask them to intervene, or at least follow up your case with the Home Office. And the Home Office usually respond when they are contacted by the local MP. Are people still coming on COS? Yes, people are still coming on COS, except under the 6135 care and 6136 senior care. Any other SOC codes or eligible work, then they can come on that, except on the care. My dependents got their visas but are still in Zimbabwe. Okay, so I think I've responded something similar. You potentially, yes, you can switch to the new employer and get your visa, or even when you're still switching. The important thing is, as long as the old employer has not contacted the Home Office to curtail your visa and your visa is not yet curtailed, you can make that visa application. The Home Office is good with most of the sponsored care visa or skilled worker, because they normally make decisions within a week, at most 3 weeks, unless if there's any other complications which are there, which you need to consider yourself whether or not that will be beneficial to your family. If they're able to come straight away, I would say that's the best solution for them to come, and then you switch. But if circumstances don't allow and you have to switch, then you can submit your switching application. And if the Home Office has got any questions, then those questions can be responded to. Okay. So those are the questions that I had to cover today. Unless if someone else has got any other questions, that will be our presentation for today. I do not think I've got any other questions. Let me just check if there's anything from YouTube. From YouTube, people don't normally ask questions. All right, there's no questions on YouTube as well. There's no comments on YouTube as well. So thank you so much for switching in. My name is Andrew Nyamayaro, or I'm from Tanlaw Solicitors. Please, this is a general information. For bespoke specific advice, consult your lawyer, or you can come down to Tanlaw Solicitors who can help you. You can like our page on Facebook. You can also subscribe to our YouTube channel. We've got a lot of information that is there. Apart from immigration, we deal with employment, family, civil disputes, advice for businesses, wills, if you want to draft a will or you've got a will, and probate, which is dealing with your estate and so forth. So those are all the other things that we deal with. Next week, I hope and I intend to answer questions on employment law as much as I can. But for today, thank you so much for switching in, and we meet again.